So this happens not infrequently, right? And can be evidence of discrimination. You've got a bunch of great reviews, a bunch of great reports from your company, from your boss, and then despite that, you're fired because of one alleged bad incident. And that can be evidence of discrimination. So we get lots of comments, and thank you for those, by the way, on our videos. I'm going to be going through some of them that we got on our YouTube videos and answering them. The question is, as a devoted listener of your podcast for several months, I have a question. My brother, a union member, was recently dismissed from his job as a private college bus driver following a verbal altercation. The company claims he was an at-will employee despite his union membership. Is the termination legally sound? So that's a great question. So just because you are a member of a union doesn't necessarily change your at-will status. Now that said, unions, you often will have what's called a collective bargaining agreement with the company that determines your benefits and can detail the way the company is supposed to respond when it is terminating someone. So I'm sorry that this happened to your brother. If he's in an at-will state, which are most of them, he is still at will, but he may have rights under his collective bargaining agreement that would not be available to somebody else who's not under the collective bargaining agreement. So he should talk to his union rep, and it's worth talking to an attorney. I don't know what the verbal altercation was, but it is possible that he was responding to some kind of harassment or that he had some legal basis for what he did. And it's worth talking to an attorney to figure that out. Now, it's also possible that he didn't. He was just having a bad day and he got into an argument with someone at work, and that could be actionable. That means the company could legally fire him. The question then is, did the company act within the confines or follow the rules of the collective bargaining agreement? So I wish your brother the best of luck. Here's another one about the EEO process. So this is the process that you go through if you are a federal worker, which is slightly different than you're in the private sector. So the question is, great information. What about when the federal agency or the EEO investigator, the one who creates what's called the ROI, the report of investigation, which is can be a big, thick document with a bunch of evidence, is withholding documents from the ROI or alters evidence provided by the agency. So this would be a big problem. And hopefully you have an attorney in this situation, because you can go through the process of discovery, which allows you to get some of these underlying documents. Your attorney can request corrections to the ROI. There are all kinds of different processes that your attorney can use, and they're somewhat complicated, which is why it's difficult to do it by yourself. Not impossible, but it can be difficult to do it by yourself to get to whether or not your EEO investigator is in fact doing this, which would be a big no-no. So get yourself an attorney, use the discovery process and the procedures available that allow you to correct corrections to the ROI and to get at the validity of the underlying documents used. I'm sorry you're having to go through that. If a worker is injured due to a supervisor's actions, is that considered harassment or illegal? The injury was due to a prank, and the supervisor claimed they did not intend to injure the worker. Also, is it illegal to deny workplace accommodation and workers' compensation benefits for the injury caused at work and to terminate the employee for refusing to seek workers' compensation benefits? So a lot to unpack here. It's important to remember that although they're both employment-related issues, workers' compensation and employment law claims, particularly as it goes to harassment and discrimination, are generally separate. So workers' compensation usually is, as here, you suffered an injury at work, and then you've got to proceed under that statute, the workers' compensation statute, which is very different than discrimination statutes. So all these questions as to, your injury at work, whether it's due to a prank, there could be some overlap, but generally, if you're going to get compensation for the injury itself, let's say you suffered a broken arm here, you'd go through the workers' compensation process. If it was also part of illegal discrimination, let's say that this supervisor only does this to people who are of Hispanic origin, okay, well that would be illegal, and so you'd have a mix of workers' compensation and discrimination, but they're separate cases, and often you might need separate lawyers, a workers' compensation lawyer and one to handle the employment case. So there can be some overlap, but generally if there's an injury at work, it goes through compensation and you need an attorney who does workers' compensation. For instance, our law firm does not do workers' compensation, so we can handle the discrimination or the retaliation matter, but we'd have to get co-counsel or to direct you to somebody else to do the workers' compensation. And often vice versa is true. People who do workers' compensation don't necessarily do the discrimination or retaliation aspect. I've never heard of someone getting fired for refusing to seek workers' compensation benefits. Workers' compensation is usually a state law issue, so you'd want to talk to a workers' compensation attorney in your state. I have heard of workers being retaliated against or fired for filing workers' compensation. It depends on the state, but if like in Virginia, there's a statute that makes it illegal for companies to retaliate against you or fire you just for the fact that you sought appropriate compensation under a workers' compensation statute. So I would say talk to an attorney in your state about that, about whether there's protection for engaging in the workers' compensation process or not engaging in this case. There could be a state statute that applies. All right, here's another one. What if I was fired for poor work performance after documentation of great work performance and they decided to use a past incident to justify my termination? The employers refused to show evidence after their written statement. So this happens not infrequently, right, and can be evidence of discrimination. You've got a bunch of great reviews, a bunch of great reports from your company, from your boss, and then despite that, you're fired because of one alleged bad incident, and that can be evidence of discrimination, right? And so we see this all the time because the employer, in this case, is smart enough to know not to come right out and say, well, we don't like that you reported this, or we don't like that how you behaved in this way, or we don't like that you're pregnant, or any kind of protected activity you might be engaged in, and then try to justify their discrimination by pointing to one incident. So I don't know what the incident is in this case. I mean, it is possible that if it's serious enough that it could be the basis for a termination, but it sounds here like they're reaching back for one that was way in the past, which is really suspicious. So it sounds like if it wasn't bad enough for them to act upon at the time, then it shouldn't be bad enough to act on now, especially since you've gotten a lot of great reviews in the interim. So I'd say it's definitely worth talking to an attorney. The second part of this, the employer refused to show evidence after their written statement. In most states, they're not required to. If you're just asking for it at work or asking for it at HR, you're not entitled. In some states you are, but in a lot of states you're not even entitled to your file, and the employer doesn't have to tell you anything about the reason for termination. I mean, that's what the litigation process is about. If you end up filing at the EEOC or a similar agency, the employer has to give some justification then, and certainly if you file in court and can go through the discovery process, the employer will have to, by law, justify the reason for their termination. But if it's just you asking, unfortunately, they're probably, I don't know what state you're in, but they're probably not required to give any justification for their termination or to show you any evidence. You're going to have to push it a little bit farther. Sometimes if you hire an attorney and the attorney does something called sending a demand letter to the employer, and this is before anything's filed, the employer will share some information, but even then the employer is not required to by law. It's only when you get into filing with the EEOC, if your claim is one that has to be filed with the EEOC, or when you get to court, that laws kick in that require your employer to give some justification for what happened. That's a wrap for today's questions. Thanks for being part of the conversation. Got something you're wondering about? Hit the comments and let's keep it going.